Kevin Hornbeck, Missouri delegation. I'd like to reserve my right to yield any remaining time to my closing summation.
That is your right.
You hear it over and over again throughout every news source in America. 2 people passed away last night after spending hours in ICU as a result of a drunk driving crash. My fellow delegates, stories like these plague the nation, as in 2008, nearly 12,000 people's lives were taken as a result of a drunk driver, while over 33,000 people were injured by such carelessness. Also in 2008, nearly 1.5 million people were arrested for driving while intoxicated, while another 400,000 people refused all BAC testing. Right now, many states, through their current implied consent laws, make it illegal for a driver to refuse a field sobriety test. However, in all states other than South Dakota, persons have the right to refuse all BAC testing, from a breathalyzer to urine or blood sample, just like the 400,000 people chose to do in 2008. But this refusal does come with consequences, such as having one's license revoked for a year, or being detained by an officer and put in prison for up to a year. Or they can be detained until a warrant is obtained. However, a search warrant is not easily obtained, as it can take up to 6 hours to receive one, by which time the suspect will have metabolized or processed some, if not all, of the alcohol in their body. Currently, what we are doing is giving every person the opportunity to drive on America's roads without enforcing a guaranteed consequence if they fail to abide by the laws. My proposal creates a nation where, when an individual starts their engine in America, he or she implicitly consents to abide by the laws of our roads. No longer will an injustice occur in which a person can evade a DUI sentence simply by refusing a BAC test. Everyone will have the opportunity to drive on America's roads, but drunk drivers will not be given the opportunity to avoid conviction because they have failed to abide by the law. This proposal upholds the very freedom and equality that this great nation was founded upon. Drunk drivers will be rightly and properly sentenced, while lives of innocent Americans will be saved as we strive for a better, as we strive for an equal, and as we strive for a safer America. Thank you. I yield the remainder of my time to my closing summation.
Thank you, Mr. Chair. Katie Boyd, Washington delegation. Fellow delegates, although he is a strong advocate for laws that crack down on drunk driving, Judge Charles Shudson of the Wisconsin State Court of Appeals says that the state's blood drawing procedures are painfully close to a violation of civil liberties. More than just being a violation of a person's right to refuse such an invasive test, all forms of blood alcohol content testing have proven dangerously inaccurate. If those pulled over on suspicion of DUI chose to be subjected to a breathalyzer, all of the following could skew the results: cell phones, police radios, electrical interference, moisture, dirt, and tobacco smoke, blood, vomit, retainers, or alcohol present in a person's mouth, a person's breathing rate caused by vigorous exercise, hyperventilation, or a person holding his or her breath, or if law enforcement personnel fail to use breathalyzers properly or fail to maintain and recalibrate units when necessary. Research from alcoholtestinfo.com, which is aimed at reducing drunk driving, also says that breathalyzer results can vary as much as 15% from actual content when all other conditions for this test have been met. Furthermore, urine tests indicate the presence of alcohol in a person's system from as many as 80 hours before the test, and do not necessarily indicate that a person was intoxicated at the time of the test. We, as a country, do not allow lie detector tests to be admissible in our court cases because of their proven inaccuracy, yet this proposal would disallow suspected people a means of avoiding such inaccurate tests being used against them in a court of law. Now, the author would have you believe that if a person did not wish to subject his or herself to the inaccuracies of a breathalyzer or urine test, he or she could forcibly be taken to a hospital to have his or her blood drawn for a more accurate test. This is an even worse solution for 2 reasons. 1, according to WebMD.com, blood tests can be inaccurate if rubbing alcohol is used to clean the site before drawing blood, a person is diabetic, a person has taken cough medicines or herbal supplements that contain alcohol, like kava or ginseng, or if a person takes prescription medications. Moreover, anyone in this room that has taken a statistics class knows that one sample is never enough for accurately reflecting a true population, and this is also true for BAC testing. 2, and perhaps more importantly, should the government be able to force medical professionals who are bound by honor and the Hippocratic Oath to obey patients' treatment wishes and protect their privacy, do otherwise by forcing BAC tests on the suspects? While I appreciate the intent of this proposal, it would violate the rights not only of those suspected of DUIs, but of some of the most highly regarded citizens in society, doctors, while allowing inaccurate tests to dominate the judicial system, making the cons for this proposal much outweigh the pros. Thank you, and I yield the remainder of my time to the chair.
Driving is a privilege, not a right. It is one of those activities where the stakes are at their highest and lives are on the line. The entire system of driving is a system that relies on one thing: trust. When you sign that line for your license, not only are you agreeing to meet the government standards, you are making a promise to every other driver on the road that you will do everything you can to be safe and not put their lives on the line. There should be no discrepancy or leniency on such safety. I know that right now some of you are concerned that this may be a state rights issue, but here are some interesting facts to consider. The 14th Amendment says that the federal government supersedes state interest in the interest of public safety. Also, if you don't buy that argument, when the federal government wanted the drinking age raised, they threatened to revoke highway fund money. When they wanted the blood alcohol concentration level for a DUI to be dropped from 0.1 to 0.08, they did the same thing. So even though it is constitutionally allowed, this proposal can be done, although I stress that it is actually constitutional. One final thing I would have to say is that if you were innocent, why would you deny the right for a BAC test? You have nothing to lose by taking it? Based on the previous delegate's comments, she practically claims that the BAC system is completely flawed, but that's not the actual purpose of this proposal. It simply allows that with the methods in place, we should take advantage of the situations we have. And I yield the remainder of my time to the author.